we have laws which were our instrument to rule. And I think we did. What happened? At times I have a problem to face judges and everybody else, because I don't think they do what we did.
Before colonialism, Africa had its own legal systems, deeply rooted in community, culture, and justice. But in today's modern world, with globalization and human rights at the forefront, are these traditions still relevant? Let's explore if Africa needs to look back to move forward. Former South African President Jacob Zuma has been making waves with his recent statements advocating for African nations to develop their own legal frameworks and shed their reliance on Western-style laws. This bold proposal has sparked intense debate, with some hailing it as a long overdue move towards self-governance, while others warn of the risk of inconsistency and erosion of human rights. Across the continent, many African countries are still wrestling with the legacy of colonialism, especially in the way their laws are shaped. Former President Jacob Zuma recently asked, open quote, "If we are free, why are we not allowed to make our own laws?" Close quote. It's a powerful question that forces us to rethink whether modern African nations should return to their pre-colonial legal traditions or continue evolving under Western-style systems. In this video, we'll dive deep into the arguments for and against the relevance of these ancient legal systems today. Pre-colonial African societies had legal systems that governed everything from land dispute to marriages, often focused on communal harmony, mediation, and reconciliation. Many argue that these systems were better suited to the social dynamics of African communities than the adversarial court systems introduced by colonial powers. So, should African nations revive these traditions? Let's break it down.
Now, as a result of the conquest and colonization, kwafika umlungu wazofaka eyakhe i-culture, wazofaka i-legal system yakhe. I call it illegal system. Wazoyifaka, zashintsha izinto. The result is that umthetho osenkantolo, which we have mastered, Abelungu, don't believe it. Umthetho lona which we have mastered, ngaphezu kwawo, it was imposed upon us, it was forced down our throats. Alas, we have mastered it even better than that. Now we need one day to Africanize the law. Africanizing the law means different things to different people. I will tell you what I mean. Africanizing the law means the law must be, after all, law is about regulating human behavior. In simple English, it's about regulating human behavior, right? Now, what is needed when I say the law must be Africanized? The law must be a reflection of the aspirations, the beliefs, the value systems of the majority of the country.
Firstly, advocates of pre-colonial traditions point to their deep cultural roots. These systems reflected African values of unity, justice, and respect for elders. Restoring them could strengthen cultural pride and identity, something that many feel was eroded by colonial rule. Additionally, pre-colonial systems prioritize reconciliation and communal solutions, which could offer an alternative to today's often impersonal and punitive justice systems. Imagine solving a family dispute not in court, but through community-led mediation. There is something powerful in that. However, there are significant challenges. Pre-colonial legal systems were designed for smaller, simpler societies. Today, African nations face complex legal issues like international trade, cybercrime, and corporate governance. Can ancient systems really address these modern problems? Moreover, some pre-colonial laws were patriarchal or hierarchical, which clashes with today's values of human rights and gender equality. Should we really bring back systems that might undermine progress on these fronts?
1994 is not equals to 1912, if you understand South African political context. First president of the ANC is Langel Balele Dube. He gathered the kings after the Land Act was passed on the 19th of June, asking kings, do you like this law? They said, we don't like this law. They contributed money to say, go to US, go to Britain, Portugal, France, and tell these powers to say, we don't want this as kings. The law of jurisdiction does not allow that a foreign law be used in a foreign land. So it is illegal. It is illegal that the Romans and the Dutch and the British and the French and the Germans and the Spanish and the Portuguese to come here, practice their law here. This is not Rome. This is not Dutch. This is not Britain. This is not Portugal. This is African. But our judges, our justices, they are good at applying a foreign law in a foreign land. And they are saying nothing about it. It's wrong. My lot is stolen from a king who presided in his traditional council and judging his matters. You say my lord because you are referring to a landlord. He had judicial powers to judge over his land. Where is the authority to judge matters of the kings today? They say kings' judgments are no longer admissible in court. Which court are you talking about? The Western court. Okay, fine, we don't need it anywhere. Where is ours? Our powers were usurped. I'm in love with my voice, I can talk all the time. Oh.
Many countries in Africa already used a blend of pre-colonial and modern legal systems. This hybrid approach allows traditional justice to operate in tandem with modern laws. For example, customary law governs family dispute in many rural areas, while modern statutory law handles complex economic issues. Could this be the future, an African that respects its past while embracing the modern world? Take, for example, the case of Rwanda, which has been hailed as a model for African-led lawmaking. In the aftermath of the genocide, Rwanda embarked on an ambitious program of legal reform, which aimed to create a new legal system that was tailored to the country's specific needs and context. While the results have been mixed, Rwanda's experience offers a valuable lessons for other African countries seeking to develop their own legal frameworks. In another example, the African Commission on Human Rights and People's Rights has been instrumental in promoting human rights across the continent. However, its ability to hold governments accountable has been limited by the lack of effective enforcement mechanism, highlighting the need for stronger institutions and more robust legal frameworks. Creating laws from scratch is no easy feat, and African nations will need to navigate a complex web of challenges. For one, there's the risk of inconsistent laws across different countries, which could lead to confusion and undermine the rule of law. Furthermore, the process of lawmaking is often fraught with political bias, which could result in laws that favor certain groups over others. And then, there's the question of how to ensure that these new laws align with international human rights standards, which are often seen as the gold standard for protecting individual freedoms. Despite these challenges, some African countries have made significant progress in developing their own legal frameworks, often with impressive results. Botswana, for instance, has developed a robust legal system that has enabled the country to manage its natural resources effectively and promote economic growth. Similarly, Ghana has made significant strides in promoting human rights and the rule of law, thanks in part to its vibrant civil society and independent judiciary. In conclusion, Jacob Zuma's proposition raises important questions about the role of lawmaking in Africa and the need for African nations to take ownership of their legal frameworks. While the challenges are significant, there are also compelling examples of African-led lawmaking that have succeeded in promoting development, human rights, and the rule of law. As we weigh the pros and cons of this approach, it's clear that the debate is far from over, and it's up to us to shape the future of lawmaking in Africa.
The time has come that our legal system must embrace the values of the African people. The Constitution must speak to our aspirations. It must speak to our land. It must address the issue of land. By the way, talking about the Constitution and the issue of land, I know this is a question I'm often asked. Whether is there a need to amend Section 25 of the Constitution, I don't see the need to amend it at all. It must be interpreted by a judiciary that understands the history of the African people in a purposive interpretation.
Amend the judiciary.
Exactly, transform the judiciary.
Let us know your thoughts in the comments below. Should Africa revive its pre-colonial legal systems or continue evolving under modern laws? And if you enjoyed this video, don't forget to hit that like button, subscribe to Inkarhi Its Time, and turn on notifications so you never miss a discussion that matters. Thanks for watching, and I would love to hear your thoughts on this important issue in the comments below. If you want to learn more about governance and law in Africa, be sure to check out my other videos on the subject.